Estate planning isn't about picking a document. It's about whether your family is simple or it's a complicated situation. Most lawyers will happily sell you a trust plan even when you don't need one. They think trust all the time. Will or trust is the wrong question to start with. The real question, the question you need to ask yourself, is whether your family has a fairly simple situation or is it a very complicated situation. It's not about what document do I buy. The question is what kind of plan does your family really need to avoid probate and to keep out of court during your lifetime? So there's two ways to get this wrong. Pick the wrong one way. Pick wrong one way and your family lands in probate. Pick wrong the other way and you overpay by about $1,000 for the same protection you never use. A few questions tell you which plan fits your family the best, a trust or a beneficiary-based plan. A will does not keep your family out of probate. A will guarantees probate most of the time. A judge has to look at it before anything happens. They have to approve it, and it has to basically be activated through the court system. So the choice was never really will or trust. A plain will takes your family to court either way. The real choice is that there's two ways to skip probate. The first choice is a beneficiary plan. You name who gets what directly. Second path is a trust. It's a trust you control. One costs less, one costs more. One does a little less, one does more. So we're going to compare this and dig into the difference between the two. A beneficiary deed on a house, a payable on death, beneficiaries on your retirement accounts, life insurance, set your beneficiary. Every one of those skips the probate. Stack them up, and your whole estate plan passes outside of the court system. A trust while you're alive, you put your property into the trust that you fully control. Now, when you pass, the person you've picked hands everything out by your rules. No judge, but it costs more to set up than the beneficiary plan. Well, that's because it can do more. So why pay extra? I talk people out of trust all the time. Before Arkansas had the beneficiary deed, and the beneficiary deed kept things away from Medicaid, the trust was about the only way to keep a house out of probate. So trust got used and sold every day, and that habit has stuck. A lot of people get the advice from others. You need a trust, you need a trust, you need a trust. But they don't have a good reason why. Now, the beneficiary deed does that job for less money up front. Let's put a number on it. I do a beneficiary plan for about $1,000 less than I do a trust-based plan. A lot of lawyers always point you at a trust. I will point you at the plan that works for your family that protects it just as well. A few simple questions literally tell you when you need a trust. It's a short set of yes-no questions. If any answer is yes, you likely need a trust. If no, you might still need a trust, but the beneficiary plan probably does the job. Okay. Do you have any heirs or children under 18 years old? Legally, they can't own or control property, so we use a trust. Are you leaving something to somebody with special needs, or they're on government benefits? A direct inheritance can ruin those government benefits, maybe when they need them the most. Do you have any children that struggle with money or with addiction problems? And I'm not just talking about drugs and alcohol. It can be an addiction to gambling or shopping where they're just not managing their money well, and you want somebody else to manage that for them. You want to put conditions or timing on the money. We have a lot of parents. They don't want their kids to have an inheritance at 18 or even 21, maybe not even 25. We often recommend that people do an inheritance with rules like some at 25, 30, and 35. We've had parents say 65, make it their retirement. We've had parents, that give it all to them at 25. I think it's best to spread it out and let them grow into handling money. Any yes to these questions leads me to think you need a trust. Now, two things a trust doesn't do. It's not a tax dodge. It does not keep you away from inheritance tax at all. There's no tax advantage during your lifetime, and the way the IRS has it structured, there's no advantage to the taxes after your lifetime. And it's not the cheap way to avoid a guardianship. That's what powers of attorney are for. And they're at a fraction of the cost of a trust-based plan. Now, both documents can age out. We have banks that have reported to us, hey, that power of attorney is more than 5 years old, we can't accept it. That certificate of trust, it's over 5 years old and we won't accept it. And that really brings up problems with trust when the trustee is now incapacitated and we need another trustee to take over and the bank won't accept the old paperwork. So what we do is we tell our clients, we want you to go to your bank in the next couple of days and we want them to get your powers of attorney filed with the bank, and we want you, if you did a trust, to get that certificate of trust filed with the bank. That's our experience. Both age out, so we want to keep our documents fresh. If you're really concerned, we suggest you come back in every 5 years and just sign a new power of attorney and go file it again. That way, we don't have a problem with a 5-year rule. It's not a law. It's not a statewide rule. It seems to be bank by bank. For either path, you should have powers of attorney. Everything else is about after you're gone. Powers of attorney protect you and your family while you're alive, but they protect you when you can't make decisions. Without them, your family has to go to court and ask a judge for the permission to manage your money and your health care. A guardianship is not easy on the family. Sometimes it's not easy on the person you're getting guardianship over. A lot of times, do-it-yourself will kits will skip this. They're just the will. But one of the most important things is the power of attorney. Your durable power of attorney for health care, or not for health care, for finances, personal and legal decisions, and a health care power of attorney to name somebody you trust and that knows you to make medical decisions when you can't. So don't ask will or trust. Ask whether you have a straightforward situation or something more complicated. That's how you pick your plan. Straightforward situation, beneficiary plan plus powers of attorney. More complicated situation, a trust that holds and protects by your rules. Now, if you want to know more, you want to talk to me, book a free call or call the office, click the link, come in and talk to us. We'll spend 30 to 60 minutes talking about your family, your goals, exactly what you want, and you'll leave knowing exactly which plan fits your family the best, and we'll give you the price up front. We're not going to surprise you with it. We work in estate planning on a flat fee.